Just presented it as he recommended.
Listen to the tape last night.
Oh, okay.
Order the Board of Commissioners meeting for April 5th. Chair of the Board of Health is here, so Jeanette, would you lead us in the Pledge of Allegiance?
Honored. I pledge
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call.
Mr. Chapman?
Here.
Commissioner O'Donnell?
Here.
Administrator Jones?
I'm here.
Request for modifications or approval of the agenda.
Thank you. We do have two that we wanted to request. Item 2B, in agreement with Mrs. Pearl Williams for solid waste and junk vehicle disposal. And item 4B, resolution requesting dismissal of cause number 16-2-00247-4.
I move to approve the agenda as amended.
Moved and seconded, all in favor?
Aye.
Motion carries. Public comment for agenda items. Is there any member of the public wishing to make comment on agenda items?
Still in the dark house, Clallam County Treasurer, courthouse. I would like to comment on the proposed resolution requesting to rescind clause number 16-2-00247-4, claim for declaratory relief and petition for writ of mandamus, which is a lawsuit that the county commissioners filed against me. I want this dismissed with prejudice rather than without prejudice, as I understand this proposed resolution right now. If this lawsuit is not dismissed with prejudice, it means that every day when I come to the office, I can expect to be reserved with a swarm of sheriff deputies coming to my office. If this cause number is not dismissed with prejudice, I will renew my request and insist on having appointed to me a lawyer at taxpayer expense, which I find utterly insulting on behalf of the taxpayers. Because the message will remain clear, which is do as the prosecutor tells me to do or else. And this case is not about transparency. I was named Person of the Year for my whistleblowing. Well, this case is not about transparency. This case hits the prosecutor's attempted precedent-setting right to redact what I would like to disclose. That is what this is all about. I promised a report last year on certain issues, and the message is very clear here. What I have that I want to disclose, that I want to be transparent about, is subject to the prosecutor's attempt to redact. That's what this case is all about. I want this to be dismissed with prejudice, and otherwise I will pursue my right to an attorney. Otherwise, I don't see what there is to negotiate when this is hanging over my head. Every given day, do as you're told. Are you going to be reserved? Do as you're told. And we're going to be finding ourselves in a Supreme Court case arguing about my right, and anybody's right in this courthouse, to speak their mind about how they feel about or what's going on in this courthouse. And that's what this is all about. Anybody in this courthouse this political season, they write a letter to the editor, they write a letter to Court of Call, and you are subject to having your personal laptop turned over. This is about, very much, this is about telling all of us in the courthouse to sit down and shut up or else. That is what this is all about. And it has been. I have been telling you now that for years, that that's what you're doing, or certain people have been doing. They have been telling me to shut up, sit down, or else. And this is what this lawsuit's been about, and this is about your refusal to dismiss this with prejudice. It's still about do as you're told, or else. And I was elected by the same voters as you are. It is my job as the county treasurer to safeguard the taxpayer funds until dispersed according to law. I want to execute that right according to my interpretation of what that means, according to my interpretation of my oath of office, not the prosecutor's oath of office, as the county administrator has told me in one case, in an email that said it was my job, my duty as an elected official to do whatever it is the prosecutor tells me to do. Well, I totally disagree with that. What I've been accused of so far by prosecutors is an ardent champion of taxpayer rights. And for that sin, I've been punished over and over and over again. And you're doing it here. You're telling me that by refusing to dismiss this lawsuit with prejudice, just shut up and sit down or else. I take incredible issue with that. And I guess that's what we'll be talking about. My right to execute my oath of office and to speak up about what I think is going on without redaction. Thank you very much.
Two things. The agenda item is I do want to thank you for resolution rescinding the lawsuit. I was unfortunately, I've been hanging around here for 40 years, and I was really shocked when I heard that discussion yesterday. It was my opinion. I could be wrong. So I would like to have the public understand what went on. It was my belief that if the prosecutor wanted to file something on behalf of Clallam County, that he had to have the approval of the county commissioners. Because at the charter, when we asked the question, who is the county, we were told it is the county commissioners. I don't know if that's true or not, but that's what we were told. So to have a lawsuit filed without your concurrence, and I guess there is some question about whether you concurred, but yesterday, a citizen filed a Freedom of Information Act request, asked for documentation showing that you agreed to file that lawsuit, and was quickly told there was no such record. I know from personal experience that decision could not have been made in executive session, because we know that under OPMA you cannot make decisions in executive session. You can only discuss them. The decision is made has to be done in open session. So since there is no record, we must assume that you were not apprised nor approved the filing of that suit. So I thank you for your stand. I just think that citizens are getting really tired of this volatility and this whatever's going on from the local to the national, and that you may have seen there was actually a paid ad in the paper of a prayer for civility, and it was sent out to some of the elected officials. I mean, we have a wonderful PDRC in this community. I would hope we would move to a process of resolving through negotiation and mediation. It's more rational, it's better for the community, it's better for the citizens. So anyway, my second comment is not on your agenda, but it was about your presentation by the Navy yesterday. So can I make a couple of comments about that? I've done review of grants, and frankly, if the presentation I heard yesterday was a grant application, I wouldn't fund it. The needs section was so poorly done as to be, I just was amazed that they could not present a need. In fact, it was shocking when someone asked them about what alternatives, and Nia Bay was discounted, not for, any kind of really scientific reason, but because the people who would be posted there wouldn't have access to shopping. Well, boy, that's a different Navy than my husband served in. When he was on the aircraft carrier for months at a time off the coast of Vietnam, no one cared about his access to shopping. So I just could not believe that was the best they could come up with. And I don't know if Nia Bay is even interested in this facility, but I thought they're... The other thing is I would refer you to an article that appeared a few months ago in the Seattle Times on their front page, and shows Hood Canal. Basically, the entire Hood Canal coastline has been declared by the Navy basically sort of offshore. Because after all, they have ships going down Hood Canal and they have to protect them. So I think how that relates to this, Port Angeles is a working harbor. They may just be talking about this little pier, but the Navy is infamous for declaring exclusionary zones. So who knows what all the shipping that goes in and out of this harbor, how close can they get to the pier and the Navy ships coming in and out. So you may end up with a not working harbor if they declare too much of an exclusionary zone. I'd also encourage you to look at, there's tons of EIS material that was done when Northern Tier wanted to build a pier out there. And there were a lot of concerns. I noticed that the marine biologist raised some significant concerns about eelgrass. And that may sound pretty minuscule, but it was raised before because it's an essential and important part of our harbor, why it's healthy and why the sea life functions there. So I encourage you to look at that. And also, you know, if we want to look at existing facilities, there was no discussion, have they talked to the port about using existing piers, which the port is anxious to lease. So why build something new except that DOD has more money than the rest of us all put together and they need to spend it, I guess. But so as commissioners, I'm glad you asked them questions. I hope you continue to ask them questions. And I hope you get better answers than you got yesterday. So thank you.
Anybody else wishing to make comment on the agenda items? Consent agenda.
Thank you. Item 1A is approval of vouchers for the week of March 28th. Item 1B is a proclamation recognizing April 3 through 9 as National Public Health Week.
Move to approve the consent agenda.
It's moved and seconded. All in favor?
Aye.
Motion carries. Reports and presentations. So I had one proclamation. I suspect that's why Jeanette's here, is the chair of the Board of Health. So it's a proclamation recognizing April 3rd through the 9th as National Public Health Week, whereas April 3rd through the 9th marks National Public Health Week, and whereas public health started out with controlling and preventing infectious diseases, but has since grown to include access to quality health care, food safety, improving child and maternal health, screening for specific diseases, tobacco and marijuana education, prevention and control of chronic diseases, emergency preparedness, and environmental health. And whereas in keeping with the core mission of public health in 2015, I think it was supposed to be 2016 instead of 2015. Or I guess it's...
No, it's supposed to be 15, what we did
Yes.
last year. Yes, sir.
So whereas in keeping with the core mission of public health, just read what they give you, Mike. In 2015, 1,622 immunizations were given by the public health section to prevent the spread of infectious diseases. 48 children with special health care needs received 366 contacts to assist in their ongoing care. To keep residents and visitors safe, 739 inspections of food service operations were conducted and 42 food service complaints were investigated. 11,103 more syringes were taken in and exchanged to keep these off the streets and out of the playgrounds and prevent the spread of HIV and other bloodborne disease. 77 water recreation facility inspections were performed to ensure that public pool and spa facilities were free of waterborne diseases. 4,071 laboratory tests on water samples were performed to assure the quality of water used by residents and visitors in Clallam County. Water quality was monitored at selected county beaches with the result of a posting of 4 advisories and 6 closures of beaches. Conditions that resulted in a public health threat were posted to assure the health and safety of those using recreational waters. And whereas When public health works best, it is invisible in ensuring the health and safety of Clallam County residents, but by no means should be undervalued. Now therefore be it proclaimed, the Board of Clallam County Commissioners hereby recognizes April 3rd through the 9th as National Public Health Week in Clallam County and encourages all citizens to take steps to prevent and control diseases in their families and community and support policies and programs that help them do so. Signed this 5th day of April by the Board of Commissioners. So I don't know if Jeanette or Iva, if either one of you have any comments?
I do.
You do?
Yes.
Iva Burks, Director of Health and Human Services. Thank you, Commissioners, for recognizing National Public Health Week. All the figures you went through, that's very important to us, but in addition to those things, it was a difficult year last year. We started the year with our 27-year health officer, 27 years in the job, health officer, retiring. Right after that, we had an avian flu outbreak in the swim area. Then we had a measles epidemic. Then we were able to get an interim health officer, who is now the chair of the Board of Health. Then we had naloxone come upon us, and we were able to distribute in our syringe services program. And all of that happened, and that was only June. So it's a very, very hard-working year for staff. So I accept this on behalf of the staff, the Health and Human Services Department, that are very dedicated staff, very good staff, and we appreciate the recognition. Thank you.
Jeanette, do you have anything you want to add?
Ditto.
Again, public thanks to you, Jeanette, for stepping in and serving as the interim health officer and then for 10 or 12 years now or as on the Board of Health. And many times elected chair. I think you're the most elected chair of the Board of Health over your time. So thank you so much for your service so far in a myriad of ways. So, Mark?
Last week, all 3 Clallam County Commissioners attended an informational meeting along with the county commissioners from Kitsap and Jefferson counties about the Salish Behavioral Health Organization, which is the umbrella organization amongst the 3 counties that is working to combine the care and service for behavioral health issues along with chemical dependency issues and people who suffer from both of those. And it's a difficult and challenging new system, which a lot of people are working very hard to figure out how to implement. I liken it to having a puzzle, but you don't have the box that shows you what the puzzle is supposed to look like, and you're not starting out with all the pieces. So it's a little bit of a challenge. One of the biggest challenges is that the billing systems and structure and way that chemical dependency treatment centers and organizations have used don't really match the new system. And one thing that I just wanted to highlight that our county is doing under Iva's direction and that of our Department of Health and Human Services is come up with a creative, I don't know if we'll see if it's a solution, but at least a creative idea to help address the need to provide additional support to some of our chemical dependency treatment centers to help them be more effective. And so I was pleased to be able to highlight that for the other counties and just wanted to say publicly I appreciate your extra proactive efforts to try and help our chemical dependency providers be successful and effective in this transition. And as always, we have a lot to be proud of our effort here in Clallam County. So thank you.
Nothing from me.
Contracts and agreements.
Item 2A is amendment number 7, Department of Health adding funding, and that increase in the amount of $17,647, all as was discussed yesterday in work session.
All right, move to approve Amendment 7 with the Department of Health.
It's moved and seconded. Any questions or comments? All in favor?
Aye.
Motion carries.
Item 2B is an agreement with Mrs. Pearl Williams, basically a landowner agreement for solid waste and junk vehicle disposal between the Department of Community Development, Code Enforcement, Health and Human Services, Environmental Health Division, and the Sheriff's Office chain gang to enter the property and remove solid waste and junk vehicles. Budgetary impact is left blank. I can tell you in my read, we're doing this at county expense. We don't know what that'll be. Presumably that will come later if it can't be absorbed in the current budgets of each of these departments.
I move to approve the agreement with Pearl Williams.
It's moved and seconded. Questions, comments? All in favor?
Aye.
Motion carries. Bids and awards.
Item 3A is a notice of call for bids to be received no later than 10 a.m. April 26, 2016 for the Fairgrounds Floral Barn Structural Improvement Project, all as was discussed yesterday in work session. This is a REAP 1 project fund.
I move to call for bids to be received no later than 10 a.m. April 26, 2016 for the Fairgrounds Floral Barn Structural Improvements Project.
It's moved and seconded. Any questions, comments? All in favor?
Aye.
Motion carries.
And item 3B is a request for proposals to be received no later than 12 p.m. May 6th for evaluation, template development, and data analysis, chemical dependency mental health program fund direct services.
Move to approve the request for proposals to be received no later than noon, May 6th of 2016 for evaluation, template development, and data analysis, chemical dependency / mental health program.
Moved and seconded. Any further questions or comments? All in favor?
Aye.
Motion carries. Administration.
Item 4A is a resolution authorizing expenditure from the Hotel Motel Tax Fund to increase the approved funding to the Clallam CQ Chamber of Commerce by $10,000, all as was discussed in work session on March 28th.
Move to approve the resolution authorizing expenditure from the Hotel Motel Tax Fund.
It's moved and seconded. Any questions, comments?
No, I guess I just will comment that we've discussed this in work session twice. Commissioner Peach has had the opportunity to comment on it and was fine with our going ahead and voting on it in his absence today.
All in favor?
Aye.
Motion carries.
Item 4B is a resolution requesting the prosecutor dismiss cause number 16-2-00247-4, complaint for declaratory relief and petition for writ of mandamus.
So before we have any motions, I'd like to ask Mark, can you explain to me well, first of all, can you explain to me what you did yesterday and then explain the difference between without prejudice and with prejudice? Being a lawyer, those are terms that I'm quite honestly not sure I'm familiar with or they're fully. So there was a concern over the word without versus with, and then I believe you took some action yesterday. So
Yes, thank you, Commissioner. And so in the aftermath of our discussion yesterday, following the direction provided by a majority of the board, we went ahead and presented to a Superior Court judge a copy of an order of dismissal. That order was phrased to be without prejudice. I understood from our discussion that there was a direction from the majority of the board to withdraw, aka dismiss the suit. By the same token, I heard one county commissioner opine clearly that if we weren't able to reach resolution working together in-house, that there may be a need to refile the suit. The distinction between a dismissal with prejudice versus without is as follows. If the suit is dismissed with prejudice, it means that you cannot refile it, period. If it is dismissed without prejudice, it means that you have the technical ability to do so. And so, because I didn't hear any discussion yesterday requesting either from the board or from the treasurer that the dismissal occur with prejudice, we went ahead and sought dismissal without, and we obtained the Superior Court judge's signature on that order as of yesterday, prior to the close of business. There was some need for expediency to foreclose potential action at the hand of one of the interested parties, that being Sound Publishing. And so for that reason, we went ahead and moved swiftly to take action which we understood was consistent with the board's and the whole group's direction.
If the resolution was changed to with prejudice, would you just file an amendment with the court to change that language?
I haven't researched that specific issue, but I am aware of case law that speaks to the fact that once a case is dismissed, the court is divested of jurisdiction to do anything more with it. So I don't believe that there would likely be an ability to submit a separate order dismissing that's worded with prejudice.
The Board of Commissioners passed a resolution though indicating that we didn't want the ability for the case to be refiled, you would then, in order to refile it, you'd have to come back and convince the majority of the board that that should occur. Is that correct?
Yes, we don't, I think as the board knows, we don't have the authority to unilaterally file suits. We follow the majority of the board in that regard for suits brought in the name of the county. And so we would never file a suit absent two or more commissioners authorizing us to do that. What I can tell you as a potential workaround under the circumstances, because again, I question and frankly doubt whether we would be able to obtain a separate order of dismissal with prejudice. I can point out the obvious, which is that it takes two or more county commissioners to authorize the action, and if there's a majority of this board that is comfortable committing to simply not having that occur, I think that would be directive, frankly, because that's necessary as a condition preceding to that suit being filed again in the future.
So since in some respects the resolution we're being asked to consider is what has already occurred, and that you can dismiss it without prejudice, so could we put something in here that then indicates we would have preferred to have been dismissed with prejudice? Or I'm trying to figure out how do we send a message that we really don't want to refile, for at least for me, I'd rather not even have it on the table, that a potential lawsuit against an elected official would be on the table. It's hard to get to a negotiation settlement if there's still threats of lawsuits hanging over individuals'
Commissioner
heads.
Chapman, I disagree. I think since there's still that right hanging out there, there's absolutely no reason in my mind. I do not agree with the prosecutor's explanation that the judge cannot sign an additional order, an amended order dismissing this with prejudice. I think that is absolutely, totally still on the table. And I think that's what needs to occur here. I feel that this is, you know,
To be clear, we're glad to research that issue.
I think it's just a matter of going up there with an amended order and take out the word out without asking that the judge sign it. I think it's as simple as that. It doesn't require any research. It just requires going up there, same way you went up there yesterday, same order with the word amended and without change to with. I think this is all still just putting me, you know, no, this is wrong, absolutely wrong. You can go up there. This is all intended to keep this hanging over my head. It's all intended to keep your power to you know, force me to do as you're telling me. You can do it. I've been there. I had a long-standing practice in this Superior Court. I've won criminal trials, jury trials. I know how this works. You can go up there with an amended order, dismissing this with prejudice. And that's what I request that the board do as an act of good faith. It does not preclude Mr. Gottlieb from submitting another Public Records Act request at any time, and we're right back where we were. This is an act of good faith, that if this county, these county commissioners and the prosecutor really mean to sit down with me and discuss this and mediate this, this is an act of good faith. I think there's not good faith going on here, and it's business as usual from my perspective. That's what I'm asking, that the commissioners sign a resolution directing the prosecutor to dismiss this with prejudice. And for nothing else, I can take your resolution and go up there and just stick it in the court file. To the extent that he refuses to go up there with an amended order, I can just file it in the court file and there it is.
Personally, I would prefer to go down the route of dismissing it with prejudice. As I said yesterday, I'm not inclined to ever take legal action against an elected official. That's just how I feel.
What I believe is that the treasurer is looking out for the best interest of county taxpayers and citizens. I believe that the prosecuting attorney is doing the exact same thing. And I think that that's what the commissioners are trying to do. And you know, we're at a difficult juncture here to to understand what the correct next step is. I don't know whether it is as easy as signing a piece of paper or whether it's not. And I want to give ourselves every opportunity to do this correctly. And I'm not interested, as is Commissioner Chapman, in taking legal action against another elected official, and we don't want to do that. So I guess my suggestion at this point would be to take no action on this resolution today. I would like to understand better what the process and implications might be for dismissal with prejudice versus without, because I want to give ourselves every opportunity to make positive progress.
Well, Commissioner Osias, if I may speak up, if you simply sign a resolution today that dismisses this with prejudice, then does not preclude either the judge signs it or not. Then we can go up there together, the prosecutor and I, with an amended order, dismissing with prejudice, and together we will present it to the judge, and together then we'll find out what the judge has to say about it, whether he will sign it or not. This is not an issue for, the prosecutor can research this up, left, right, and down, and we'll get a 40-page legal memorandum with all sorts of legalese, and we will still not have a conclusion. This is basically what it comes down to. If you sign this resolution today with prejudice, then at the very least, I can stick it in the court file, and we can go up there together with an amended order, and for that matter, any of you can join me, then join us, go up there to the judge and ask him, Judge, can you sign this amended order, dismissing this with prejudice, and then we'll know. It's as simple as that. As simple as he went up there yesterday, very quickly apparently. We can go up there today, very quickly, and ask the judge to sign this with prejudice. It's as simple as that. Either he does or he doesn't. And then we know. Because researching this isn't going to get us anywhere. I will disagree with what he comes up with, and we will have 40-page memories, and we can talk about this one for months. It's a practical, very practical solution.
To be clear, Commissioners, and Celinda, I'm not saying we won't do it. I'm just simply saying I haven't had an opportunity to research the discrete issue. I don't anticipate it would entail much effort. And if there's a legal ability to make the ask, and it's ethical to do so, we're glad to do that. I just simply want to make sure there's nothing in case law that states that that's not available as a legal course. That's all.
Yeah, and all I'm saying is that it's a matter of going out there and have the judge sign it. There's still a right up there that can be dismissed by the judge. There's still a right up there. And the judge can simply dismiss it with prejudice. It's as simple as that. You can go up there in 10 minutes with this amended order and ask Judge Millie to sign it. That is what I propose.
Do you have a sense for how long it would take you to do your research?
I wouldn't guess more than an hour or two. We look through our standard databases, check Westlaw, check the civil rules, for example, check the boxes reflecting due diligence and having researched the issue, and then I think we could have reached a conclusion after that. Again, I can't underscore enough that we're in a posture where there's an order that we obtained, based on my understanding of the desire from the board as a whole yesterday. That was done in good faith, frankly, expeditiously, in light of the need to meet this week to talk collectively about cooperatively resolving this. So we did move expeditiously, frankly, out of respect for all involved. Certainly didn't mean to offend anyone, and I don't believe that we did anything that was contrary to what was discussed. Had we known that there was a desire, for example, to have the dismissal be with prejudice, we would have asked for that yesterday. We didn't hear that, and so didn't know to do so. But again, I think we could probably research within the next hour or two. And again, so long as it's legal and ethical to make that ask of the Superior Court, we have no objection to doing so, if that's the will of the board.
And I received a resolution from Jim Jones yesterday because I asked for a draft resolution as soon as possible, and it was with prejudice. That is what I saw. That's what I thought was going to happen today. That's why. So, from my perspective, all you have to do, commissioners, if you really want to dismiss this with prejudice, is to sign a resolution. And then he can do his research, and then we can go up there, Commissioner Zayas, if you want to join us, with an amended order. And you can ask the judge whether this is, your understanding of whether it's whatever you come up with. This is my proposal. The three of us go up there at 1 o'clock today. That's usually the ex parte calendar, or however you did this yesterday. The three of us go up there, and you can have your research, whatever that conclusion is, and we will ask for an amended order dismissing this with prejudice.
To me, that seems an incredibly solid offer on behalf of the treasurer, and I think it would be well within the very best benefits of the Clallam County taxpayer to get this issue behind, and then you can continue to work to a resolution on the dispute. So if we don't do that today, this begins a snowball of which potentially has no end.
Absolutely.
For months or years.
Absolutely.
I think we are faced today with the very best course of action to get this issue behind us, really get back to the issue of hand, which is resolving the differences between the treasurer and the prosecuting attorney's office with regards to complying with the Open Public Meetings Act. So I strongly urge this as a course of action today. Otherwise, I don't think we'll
I will be here every single Monday and every single Tuesday talking about this issue if this doesn't get resolved today.
Commissioner, just by way of comment, I know there's been discussion casting this as a disagreement between prosecutor and treasurer. The action that was final, not to be elaborate, simply presented a series of alternatives to the Superior Court judge to draw from. We've raised, I believe, what is a legitimate question regarding organizational compliance with the Public Records Act. We stand ready to provide assistance to the county based on direction provided by a majority of the board. Frankly, if that advice is specific in nature or recommendation, we'll adopt that. Again, under the facts that are presenting, this is not a circumstance of either prosecutor versus treasurer or county versus treasurer. In reality, this is an action that was filed to seek guidance from an esteemed Superior Court judge regarding what the law requires. It's focused on the issue.
Very much county versus treasurer, and there's many other alternative avenues for finding this guidance from the MRC, from the Attorney General. There's many ways to get guidance before ever, and I would like to find any case any case where the county has filed a lawsuit of this kind for public records compliance anywhere in the state. This is an extremely aggressive course of action. There are so many other ways we can get guidance from organizations specifically funded with taxpayer money to provide that guidance. That has never even been attempted. Never. And this is putting me in the position, as with the warrants last year, of personally defending the Constitution of Washington, the Constitution of the United States, and because this is about First Amendment speech issues, putting me in the position somehow of defending those sorts of rights on my own, when there is organizations specifically providing that guidance to governments. There's, as I said, the MRC, the Attorney General, but every time I ask for an Attorney General opinion, it gets nixed. This is very much, you know, this is setting a precedent here in this county where, gee, you know, an elected official is not doing what the prosecutor tells her to do, file suit. That is so outrageously outlandish, but you know, I think we need to get back to the issue at hand here, and what Commissioner Chapman suggested, provided that agrees with me, this needs to be dismissed with prejudice today. And the simple course of action is for you to do whatever research you want, give it a couple hours, and we go out there with an amended order, and Commissioner Rosales, you can join us, and we can talk to Chris Melly, and you can, if you have your concerns, express those, and we'll see if he signs it. It's as simple as that. And I ask that the Commissioner sign a resolution directing the prosecutor to do this. And then we can all sit around the table and discuss the issues at hand and come up with alternate ways to resolve any questions. And there's many, many options to do that.
All right. I guess I'd like to start by saying that I don't believe that the prosecutor filed this contrary to the board's conversation yesterday. However, as I said earlier, I think that every party here is doing their best to do the right thing for the county and to do the right thing for county taxpayers. And I think fundamentally the commissioners, at least two of the commissioners, felt that in order to make progress, the threat of this suit needed to be withdrawn. You know, neither one of us understood sufficiently. I didn't recognize that there were two different options for how the suit could be withdrawn. And so anyhow, but I do think that it was our intent yesterday to find a path forward to talk about this in a somewhere besides the courtroom. So with that in mind, I would be willing to move to pass the resolution worded that the suit be dismissed with prejudice, and then work to make sure that that's possible. Go ahead.
Is that a motion?
Yes, I move to amend the resolution to state that the intent of the board is to dismiss the suit with prejudice.
So second.
Yes, only because you're speaking in terms of adopting a resolution that contains language contradicting what's already occurred. I would suggest that the board consider the possibility of modifying the language of the resolution to reflect that the board has no interest in refiling the suit on behalf of the county, period. The prosecutor would never file a suit like this on their own volition. And then we can pursue obtaining an order of dismissal with prejudice. We can always craft an amended resolution, but my recommendation is to have a resolution that actually tracks reality with respect to what's occurred. So there's two ways to foreclose litigation. Number one is by a court order dismissing it with prejudice. The other is, frankly, by a majority of the board taking that position, that they're not going to be filing the suit, period. If that decision is reached by this board, the suit will not be refiled. We're not going to contravene the intent of the board in filing a lawsuit.
I disagree. I think the motion that's just was submitted and seconded is what you should adopt. And again, then we can go up there and offer the amended order dismissing it to Judge Milling. If he refuses to sign it because of whatever research he may come up with, then we can come back here next week and do an alternate resolution that then reflects that reality. But at this point, I think it needs to be dismissed with prejudice, and we need to follow through with an amended order to the judge and see what the reality actually is before we start assuming it is. That is what I propose, because I do not agree that's my proposal. I'm urging you to adopt the resolution as was just offered to be amended, the way it was offered by Commissioner Zayas, and that, again, we then meet in a couple hours, and we offer an amended motion to dismiss. I haven't seen this motion to dismiss that was ordered signed. I would like to see it. Just be very simply edited as amended and we'll go up there and we'll see what the reality is. If we need to come back next week and do a resolution as proposed by the prosecutor, then we can do that.
And maybe this will help. So long as the board's willing to revisit the resolution depending upon the outcome of what happens with Superior Court, that's fine. So
That's what the two of you are saying, so to me, that seems like the best course of action. Let's try this.
if we need to come back, we can. But we're glad. I think one of my civil deputies left, and I think he's probably researching the discrete issue now. So long as we have a legal ability and an ethical ability to make that ask, the Superior Court will gladly do so.
So we try this route, and then you guys will let us know if the judge says something different.
Yes, thank you.
Mark?
Absolutely. Thank you.
Okay.
There's a motion and a second to accept the resolution rescinding case number 16-2-00247-4. One change from what was before the board is being requesting it, the case be dismissed with prejudice. Any other comments? I'd like to thank Mark. I'd like to thank Celinda. I'd like to thank Mark. I think you guys are off to a good start. And we were able to reach this resolution, and that sets up hopefully a good negotiation moving forward. So I appreciate all three of you in the spirit of cooperation today on behalf of the taxpayer.
And I'd like to also thank Mark and Christina and your office, Celinda. I would like to thank you as well. And as I said earlier, I really believe that every party here wants to do the right thing by county taxpayers. And the reason why I have hope that we're going to make some progress is because of that. And what needs to happen in order for all of us to move forward is we need to find a way to start building trust amongst each other and amongst ourselves. And there is the possibility that the county taxpayers will be liable for damages, for penalties, for some financial liability, no matter what happens here. No matter how this case turns out, there's a potential for that. And so I just want to go on record as saying that I do not believe that there has been any malfeasance. I don't believe that there is a I don't believe that there's any malfeasance here. What I do believe is that we need to find a way to build trust. And it is my sincere hope that by taking this action today, that is a small step in that direction. And I hope that that step opens up the door to turn a corner that all of us desperately want to turn. And I'm committed to doing everything that I can to help make that happen.
And all three of you have put that on the record that you're going to work and try to find a solution. I will say, just maybe a lighter moment, I've been in office for 15 years and 3 months, and I now know more about writ of mandamus, declaratory relief, and with or without prejudice than I ever could have known without. So I guess there's always new knowledge is always good, but clearly some of the terms that were thrown out over the last month or so, I did not fully understand what they meant and all the ramifications. And since I'm not a lawyer, I should have probably asked a lot more questions, and for that, I'll take responsibility. So my apologies to your office, Mark. I think that clearly some terms were thrown out, and I did not ask clear, like, what does that mean and what does that look like? Because I think there may have been some different discussions that occurred, or whatever that's worth. But now we're fully aware of what these mean, and we never understand them a little clearer, so I appreciate that. So,
and I'm sorry, I'm just going to belabor this one more moment, and because I think that's really an important point. And when I say, I think that what, to a large extent, what we're the reason why we find ourselves in this situation today is because of insufficient communication on all parts. Anybody who's ever been married or in a relationship of any kind understands how easily it is to miscommunicate. Sometimes you don't know what questions to ask. Sometimes you assume knowledge that seems obvious to you, but that the other party may not have. And at least my opinion is that that's what we're talking about. So
I just want to add one thing, and that is I proposed that Mark Nichols and I meet upstairs 5 minutes to 1 so that we can meet with Judge Melling. I'm not sure what his.
can you do that?
Usually 1 o'clock is when there is an opportunity to meet the judge.
Provided he's available, I'm glad to do that.
Excuse me?
So long as he's available, that sounds like a great idea.
Right, and if you will bring that motion as amended.
Sure.
Thank you.
Like I said, I think Brian's doing his legal legal.
yes, I'll make it happen.
Just moved and seconded, accepting the resolution. All in favor?
Aye.
Motion carries. Thank you very much. Appreciate everybody's cooperation, and I believe that the three of you will reach settlement. I don't know if settlement's the right word. We'll just
We'll work it out.
Yes, you will. I'm confident. No budget, no community development, no public works, no public hearings, public comment. Any member of the public wishing to make a comment on any issue? Thank you, Madam Treasurer. Anybody, any comment?
Turner, I'm still at Van Agnes Road. I want to concur and fully endorse the statement that we would, taxpayers, the voting citizens, would really like to see you all working as a team, since, we all voted for all of you. And what I hear today is, I tell you, you're right, communication seems to be a real issue. I hear the prosecutor tell you that he would never file anything without your permission, but it seems like maybe something was filed without your permission. And then yesterday you had some sort of meeting, and then out of that, the prosecutor went up and filed something with the court. But in that discussion, looks like you weren't told that there's 2 ways to dismiss things. Unfortunately, been there, done that, gone to court. Our attorney was very clear when he explained to us what the motion was going to be. He explained to you what was with prejudice and what was without prejudice. That was what he did to us because we were his client. So it sounds like there was a lot of miscommunication, and then I hear the treasurer say that she got a memo saying it was going to be dismissed with prejudice. So she had no problem, but then what got filed was without. So I do encourage you all to figure out how to be a team, because the public, I as a member of the public, I remain totally confused as about what happened and how it happened and why it happened. And I'm also totally confused about why there would be a suit filed in Superior Court in order to get some opinion on the Open Public Meetings Act. I don't get that piece, because I didn't think that's why you filed suits. You went to other sources, so I have no idea what the suit's about. But as the public, I'll tell you, I remain very confused, and I hope you guys work diligently on communications and becoming a team. Thank you.
I think we're doing our best to move in that direction. And this is a good first step today.
And I also, Norma, I don't think it's a completely fair characterization to imply that the prosecutor's office was going down this path on their own, I just don't think that that's what happened. And it's, as I said, you know, and as we've all acknowledged, you know, we all have more work to do, and I think what you're seeing is that you've got people who are committed to finding a way to do it. So, you know.
I only made that statement because the citizen did file an FOI yesterday on documentation that the commissioners concurred the suit should be filed, and there was no they were told there was no documentation.
I understand.
So we have to assume that if it's not documented, it didn't happen.
I understand.
Thank you.
Okay, anything else? Anybody else want to make comment before the board? If not, review of the calendar. Looks like nothing else for us this week. There's a hearing scheduled on the calendar for Thursday, April 7th. That doesn't make sense. So I think that's a history. Public hearing on Thursday, April 7th. I know of no such hearing. So we remove that from the calendar. And Thursday, Commissioner Peach is listed as the O3A. It's not a public gathering for the board. I just got it this week. Calendar stands with nothing else this week, and we'll continue this week's meeting Monday morning at 9 a.m. No objections, so ordered.